What unfolded in that federal courtroom has been described as a confrontation, a warning, even a line in the sand. Depending on who is telling the story, it was either an unprecedented assertion of judicial authority or a moment inflated by political storytelling into something larger than reality. At the center of it all is a single idea that has captured public attention: a judge facing what he believed to be deliberate obstruction, signaling that the court's patience had limits, and that those limits could include personal consequences for attorneys who crossed them. The story begins with delay. Not one delay, not two, but a pattern that many observers say had become impossible to ignore. In high-profile cases, delays are not unusual. Defense teams routinely ask for more time, citing discovery volume, scheduling conflicts, or the need for additional preparation. Most of the time, courts grant at least some flexibility. That is part of the system. But according to reporting and commentaries surrounding this case, what troubled the court was not a single request, but the cumulative effect of repeated motions, emergency filings, and procedural maneuvers that appeared to push the boundaries of zealous advocacy and drift towards something else entirely. In this environment stepped Judge Caldwell, a federal judge described by commentators as experienced, methodical, and deeply protective of the court's authority. Whether one accepts every dramatic detail attributed to him or not, the broader theme resonates with something very real in the American legal system. Judges are not passive referees. They are charged with ensuring that proceedings move forward fairly, efficiently, and without abuse of process. When a judge believes that process itself is being weaponized, the response can be firm and sometimes uncomfortable for those on the receiving end. The moment that sparked viral attention allegedly came when the defense sought yet another continuance, arguing that discovery demands required additional time. To outside observers, this sounded familiar. To the court, according to the narrative, it sounded like a repetition of arguments that had already been considered and rejected. What made this different was not just the denial of the request, but the warning that accompanied it. The message, as it has been widely interpreted, was simple and stark. Delay for legitimate reasons is one thing, delay as a strategy is another, and the court would no longer tolerate the latter. In federal court, contempt is not a symbolic concept. It is a real power with real consequences. Judges rarely invoke it lightly, especially against attorneys, because doing so escalates tensions and invites appellate scrutiny. But the mere mention of contempt, particularly when tied to personal accountability rather than abstract sanctions, changes the dynamic instantly. Lawyers are trained to advocate aggressively, but they are also officers of the court. When a judge signals that advocacy is approaching the edge of obstruction, every calculation changes. What makes this standoff so compelling is not just the personalities involved, but what it represents. Donald Trump's legal strategy across multiple cases has often been described as maximalist. File everything, challenge everything, delay wherever possible. From a purely tactical perspective, delay can be rational. Time can affect witnesses, political environments, and public attention. But courts are not blind to strategy. Over time, patterns become visible. Judges compare filings, track timelines, and notice when arguments recycle themselves under slightly different labels. The alleged production of a detailed timeline documenting delay tactics, whether literal or figurative, symbolizes something important. It reflects the idea that the court was no longer responding to motions in isolation, but evaluating behavior as a whole. That shift matters. When a judge moves from addressing individual filings to addressing conduct, the tone of a case changes. It becomes less about whether a motion is technically permissible, and more about whether the overall approach respects the court's role. For Trump's defense team, this moment reportedly marked a realization that the usual playbook might not work here. The suggestion that attorneys themselves could face consequences introduced a level of personal risk rarely encountered in high-profile defense work. Traditionally, the client bears the ultimate consequences of delay strategies. Attorneys operate with relative insulation, protected by the broad definition of advocacy. But contempt pierces that insulation. It targets the lawyer, not the client, and that distinction carries weight. Beyond the courtroom, the political and media reactions added another layer entirely. Supporters of Trump framed the confrontation as evidence of judicial overreach, arguing that the judge was attempting to intimidate defense counsel and rush proceedings for political reasons. Critics awe it as long overdue discipline, a sign that the courts were finally pushing back against tactics they viewed as abusive. As usual, the same moment was interpreted in completely different ways depending on perspective. What cannot be ignored is how quickly the narrative took on a life of its own. Words like arrest threat and courtroom showdown spread rapidly across social media. Commentary blurred into reporting. Analysis hardened into supposed fact. In an era where attention is currency, dramatic framing travels faster than careful nuance. The result is a public conversation that often feels certain, even when underlying details remain disputed or unverified. Still, even stripped of exaggeration, the core issue remains significant. The judiciary depends on compliance. Courts do not have armies or budgets comparable to the other branches of government. Their authority rests largely on legitimacy and the willingness of participants to follow orders. When that compliance appears strained, judges must decide how far to go to enforce it. Too soft, and the court risks becoming irrelevant. Too harsh, and it risks accusations of bias or abuse. Historically, there are moments when judges have chosen to assert themselves forcefully in politically sensitive cases. These moments are rarely comfortable, and they are almost always controversial. Yet they tend to be remembered as inflection points, not because everyone agreed with them, but because they clarified boundaries. This standoff, real in its essence, even if embellished in its telling, fits that pattern. Another important dimension is the message sent to other attorneys in other cases. When a judge publicly signals that procedural gamesmanship will carry consequences, it reverberates beyond a single courtroom. Lawyers pay attention to incentives. If delay brings benefit without cost, it becomes attractive. If delay introduces personal risk, behavior adjusts. That is not intimidation. It is regulation of conduct within the bounds of judicial authority. At the same time, caution is necessary. Courts must balance efficiency with fairness. Rushing a defense team can create appellate issues and undermine confidence in verdicts. Judges know this, which is why most are reluctant to push too hard. The tension between speed and justice is not new, but it becomes sharper when the defendant is a former president and current political figure. Public reaction to Trump himself, following the confrontation, only intensified scrutiny. His responses, particularly on social media, were interpreted by some as defiance and by others as political theater. From a legal standpoint, public attacks on the judiciary are risky. They can influence jury pools, provoke prosecutors, and reinforce judicial concerns about respect for the process. From a political standpoint, they energize supporters. This dual effect makes restraint difficult for someone whose brand is built on confrontation. What happens next, regardless of how one views the original confrontation, carries broader implications. If the court maintains firm control and proceedings move forward without further delay, it will reinforce the idea that even the most powerful defendants must operate within procedural limits. If, on the other hand, the confrontation fades into symbolic theater with no follow-through, it may embolden similar tactics in future cases. This is why the moment matters. Not because of a single line allegedly spoken from the bench, but because of what it represents in the ongoing struggle between legal process and strategic obstruction. The American legal system is resilient, but it is not infinitely patient. It relies on good faith participation as much as written rules. When that good faith appears to erode, judges are forced to respond. Whether Judge Caldwell's warning, as described, was as explicit as some accounts claim is almost secondary. The perception of firmness alone has already altered the conversation. Defense teams now know that courts are watching patterns, not just filings. Prosecutors know that judges may be more willing to enforce timelines. And the public has been reminded that courts, for all their procedural complexity, still possess real authority. In the end, this standoff is less about one judge or one defendant, and more about the boundaries of advocacy in a polarized era. It asks a fundamental question: how far can legal strategy go before it becomes an attack on the system itself? The answer to that question will not come from a single hearing or a viral clip. It will emerge slowly, through rulings, compliance, and the willingness of all parties to accept that the courtroom is not a campaign stage. The story of this confrontation will continue to evolve, shaped by future filings, judicial responses, and public reaction. Some will remember it as a warning shot, others will dismiss it as overhyped commentary. But beneath the noise lies a serious issue that transcends personalities. Courts must function, justice must move. And when those principles are tested, the response, whatever form it takes, defines the strength of the rule of law. Whether this moment truly changed everything or simply revealed tensions that were already there, it serves as a reminder of something fundamental. In a system built on laws rather than individuals, no strategy, no status, and no name can indefinitely override the authority of the court. That reality, more than any dramatic line or viral headline, is what gives this standoff its lasting significance. The weeks following the confrontation were marked by close observation in legal circles. Attorneys in other high-profile cases began reassessing their approach, aware that judges might scrutinize not just individual filings, but the cumulative strategy behind them. For Trump's team, the message was clear. Procedural creativity had limits, and the consequences could now extend personally to the lawyers themselves. Every motion, every request for extension, became a calculated risk, balancing client interests against the possibility of judicial censure. Meanwhile, the broader political landscape added pressure. Public commentary and social media posts amplified every nuance, framing each development as either evidence of an overreaching judiciary or a court finally asserting its authority. Journalists dissected transcripts, analysts traced timelines, and supporters and critics alike debated what the confrontation meant for the rule of law. The courtroom drama had effectively become a national conversation about legal process, political strategy, and institutional authority. Behind the headlines, the practical work of the case continued. Discovery deadlines, witness schedules, and procedural filings moved forward under the watchful eye of Judge Caldwell. The court's insistence on adherence to timelines subtly shifted the dynamics of the case. Negotiation became more structured, arguments more precise, and motions less frequent. Lawyers found themselves not merely advocating for their client, but navigating the boundaries set by a judge who had made it unmistakably clear that process could not be manipulated without consequence. Over time, observers noted a subtle but important shift. Even without issuing direct sanctions, the court's firm stance influenced behavior across multiple cases. Attorneys became more cautious in how they framed arguments, how they requested continuances, and how they approached strategic delays. What began as a single courtroom confrontation evolved into a signal to the legal community that pattern-based scrutiny could alter the calculus of advocacy. For Trump himself, the episode carried dual weight. Legally, it constrained the familiar maximalist strategy, introducing real procedural limits. Politically, it reinforced the narrative of conflict with the judiciary, energizing supporters while inviting scrutiny from critics. The tension between personal risk for lawyers and political theater for the client became a defining feature of the case's next phase. The courtroom showdown also prompted reflection on the broader responsibilities of the judiciary. Judges must balance efficiency, fairness, and impartiality, all while under the glare of public attention. The Caldwell confrontation illustrated that when participants test the limits of good faith participation, courts are compelled to act, sometimes forcefully, sometimes subtly, but always with an eye toward preserving legitimacy and authority. In the end, the confrontation's significance lies less in its theatrical moments and more in its long-term impact. It revealed that in the American legal system, strategic obstruction can be noticed, documented, and countered. Authority rests not just on rules written on paper, but on the enforcement of those rules through consistent judicial action. And in a polarized, highly publicized environment, even a single courtroom decision can reverberate far beyond its walls, shaping legal strategy, professional conduct, and public perception for months, if not years, to come. As the case progressed, the courtroom became a stage where strategy, procedure, and public perception intertwined more tightly than ever. Judge Caldwell's firm stance had already shifted the dynamics, but the defense team faced a practical challenge: how to advocate zealously for their client while staying clearly within the bounds of the court's patience. Every filing, every motion, and every request for extension was now measured not just against legal merit, but against the cumulative pattern the judge had signaled he was monitoring. The court, in turn, maintained a careful balance. Caldwell and his clerks reviewed submissions with heightened scrutiny, distinguishing between legitimate requests and tactics that could be construed as delay or obstruction. While no attorney wanted to risk contempt, prosecutors recognized an opportunity. The court's attention to patterns allowed them to challenge defenses more strategically, knowing that repeated or frivolous motions could backfire on counsel personally. The very structure of litigation began to feel different, a shift from reactive advocacy to mindful compliance. Outside the courtroom, the political theater continued unabated. Every development, from a denied motion to a brief procedural ruling, became fodder for commentary, social media posts, and cable news segments. Supporters of Trump often portrayed every judicial action as politically motivated, framing Judge Caldwell as an antagonist in a broader campaign narrative. Critics, meanwhile, highlighted the standoff as a cautionary tale about accountability and the importance of respecting judicial authority. The courtroom, though ostensibly a legal arena, had become a proxy battleground for public opinion. Yet amid the noise, the procedural realities persisted. Discovery deadlines, witness depositions, and evidentiary motions moved forward, and attorneys adjusted their approach. Some filings became more precise, others more conservative, and arguments that might once have been repeated were now carefully restructured or abandoned entirely. Even without direct sanctions, the implied threat of personal consequences reshaped behavior, a subtle but powerful reminder that judicial authority is enforced as much through expectation and perception as through formal orders. This period also revealed a broader lesson about the American legal system. The tension between strategy and procedure is inherent, but patterns of abuse cannot be ignored. Judges may tolerate delays for legitimate reasons, but when those delays appear orchestrated to impede justice, the court steps in. Caldwell's warning, whether interpreted as stern or dramatic, had already signaled that pattern-based enforcement was real. For lawyers, this meant that advocacy could no longer be treated purely as a tactical exercise. It carried responsibility, and responsibility could carry personal consequences. For Trump and his allies, the confrontation's implications extended beyond the courtroom. Legally, it constrained the familiar maximalist approach, filing everything, challenging everything, and relying on procedural momentum. Politically, it reinforced a narrative of conflict with institutions, while also reminding them that even political figures with vast resources are not immune from the practical constraints of law. Every public statement, tweet, or press appearance now had to be considered not only for its political effect, but also for its potential impact on the judicial perception of the case. Ultimately, the unfolding story underscored a simple truth about the rule of law: authority is real only when it is respected, and respect is earned through consistent enforcement. Judge Caldwell's confrontation was more than a single moment. It was a signal to the legal community, the political class, and the public that strategic obstruction has limits, and those limits are monitored closely. The standoff became a living lesson in the consequences of testing the boundaries of the judicial process, demonstrating that even the most high-profile cases must operate within the structure of law. As the weeks turned into months, the narrative continued to evolve. Attorneys became more mindful, court proceedings more structured, and observers more attuned to patterns of strategy and compliance. What had begun as a single courtroom confrontation had ripple effects across multiple dimensions: legal, political, and cultural, reminding everyone involved that in the American system, no individual, no status, and no strategy can indefinitely challenge the authority of the court without facing consequences. By the time the case reached its next major hearings, the courtroom atmosphere had transformed. What had once been a predictable rhythm of filings and motions now carried an undercurrent of caution and calculation. Attorneys were acutely aware that the judge was observing patterns, not just individual arguments, and each action was weighed against the potential for personal accountability. The defense team, once emboldened by the familiar maximalist strategy, now approached every motion with heightened deliberation, carefully framing requests to avoid any perception of obstruction. Judge Caldwell, meanwhile, maintained a steady, disciplined presence. He signaled through his rulings and comments, not just to Trump's team, but to all participants in the courtroom. That process mattered as much as outcome. His approach was neither punitive for its own sake nor politically motivated. It was procedural, a demonstration that the judiciary's authority rested on compliance, credibility, and the consistent enforcement of rules. Observers noted that even subtle reminders about deadlines, prior rulings, or evidentiary standards carried weight, shaping behavior without overt confrontation. Outside the courtroom, media coverage continued to amplify the drama. Social media threads dissected every ruling, every tone of voice, and every exchanged look. Analysts debated whether Caldwell's firmness was unprecedented or simply a reflection of long-standing judicial practice. Public opinion polarized further, with some seeing the judge as a guardian of the legal system, while others cast him as a figure imposing undue pressure in a politically charged case. Yet, behind the headlines, the practical effect was tangible. Procedural discipline increased, frivolous filings decreased, and strategic calculations became more precise. For the defense team, the implications were clear. Every request for a continuance, every nuanced argument, and every repeated motion now carried stakes beyond the immediate interest of the client. The risk of contempt, even if only implied, created a feedback loop in which caution replaced recklessness, precision replaced redundancy, and legal creativity was tempered by procedural responsibility. In effect, the courtroom had become both a legal and behavioral training ground, demonstrating how authority and compliance interact in high-profile litigation. Meanwhile, the case continued to shape broader conversations about the American judicial system. Legal scholars pointed to Caldwell's approach as a case study in pattern-based enforcement, highlighting the difference between addressing isolated filings and evaluating a lawyer's overall conduct. Prosecutors and defense attorneys alike began referencing the confrontation in other cases, acknowledging that the lessons extended beyond a single courtroom or client. The episode illustrated a central truth. The legitimacy of the courts depends not only on written rules, but on the willingness of participants to respect them. Even Trump, as a political figure and defendant, faced a new dynamic. Public messaging now had to account for the judicial perception of the case, reinforcing the idea that political theater and courtroom strategy were no longer entirely separable. Every statement or social media post could influence not only public sentiment, but also the legal environment in which his defense operated. The confrontation, once a single viral moment, had matured into a continuous reminder that procedural limits exist, and they apply to all, regardless of power or prominence. As proceedings continued, the courtroom's lessons rippled outward. Attorneys became more disciplined, judges more attuned to cumulative behavior, and the public more aware that high-profile legal battles are governed by rules that extend beyond headlines. The Caldwell confrontation, at its core, had reasserted a fundamental principle. In the American legal system, authority is earned through enforcement, compliance matters as much as advocacy, and no strategy, political, procedural, or otherwise, can indefinitely sidestep the law. In the months that followed, the case evolved less as a series of dramatic moments and more as a testament to the resilience of judicial process. Patterns of delay were curtailed, deadlines enforced, and the courtroom operated with renewed structure. What had started as a confrontation had become a precedent, a living example that even in the most high-profile cases, the machinery of justice functions best when participants recognize its boundaries. As the case moved deeper into its evidentiary and procedural phases, the stakes became increasingly tangible. Depositions, discovery disputes, and evidentiary hearings were no longer routine exercises. They were high-stakes maneuvers under the watchful eyes of both the judge and the public. The defense team, previously accustomed to aggressive, sprawling tactics, now had to carefully prioritize each action, balancing thorough representation with the risk of crossing the line of procedural propriety. Every filing was scrutinized for both content and pattern, with the implicit understanding that repeated attempts to delay or circumvent the process could carry personal consequences. Judge Caldwell's management of the courtroom reflected a subtle but unmistakable shift in authority. He enforced deadlines strictly, questioned redundant motions, and emphasized efficiency without compromising fairness. His approach was methodical rather than theatrical, a demonstration that judicial power is exercised most effectively through consistency and attention to conduct over spectacle. Attorneys, including Trump's team, quickly recognized that the courtroom had become a place where strategy had to coexist with discipline, where clever tactics could no longer rely on procedural loopholes alone. Outside the courtroom, the tension between legal process and public perception intensified. News outlets dissected every ruling, social media amplified every procedural nuance, and political commentators interpreted each event as part of a broader narrative about justice, power, and accountability. Supporters of Trump framed every rebuke or warning as evidence of bias or judicial overreach, while critics pointed to Caldwell's firmness as a rare assertion of judicial authority in the face of repeated procedural gamesmanship. Amid the media frenzy, however, the practical effect of the confrontation continued quietly. Filings became more precise. Motions were strategically consolidated, and deadlines were increasingly respected. The defense team, now operating under a heightened awareness of personal accountability, began restructuring their approach. Arguments that once would have been repeated were now carefully analyzed and presented only if essential. Requests for extensions became rare and tightly justified. Even seasoned attorneys found themselves adapting to an environment in which the cumulative impression of their conduct mattered as much as the merits of any single filing. In effect, Caldwell's courtroom had transformed into a proving ground for disciplined advocacy, demonstrating that even experienced lawyers must navigate the intersection of law, procedure, and judicial expectations. Meanwhile, the broader lesson extended beyond the immediate case. Legal scholars, practitioners, and observers recognized that the confrontation illustrated a fundamental principle of the American judicial system. Authority is maintained through compliance, and compliance is earned not through intimidation, but through consistent, transparent enforcement. By signaling that patterns of delay or obstruction could trigger accountability, even personal accountability for lawyers, the court sent a message that extended far beyond the walls of a single courtroom. For Trump himself, the confrontation subtly reshaped strategy. Political messaging and legal maneuvering became intertwined in new ways, as statements, appearances, and filings were all considered not only for their immediate effect, but also for their potential influence on judicial perception. The dual pressures of legal responsibility and political theater required a recalibration of tactics, demonstrating that in high-profile cases, the courtroom can never be fully isolated from public scrutiny. As the case approached its subsequent hearings, the standoff's lasting impact was increasingly evident. Procedural compliance improved, strategic arguments became more disciplined, and both sides recognized the limits of pushing the court beyond its patience. What had begun as a dramatic moment of confrontation had matured into a structured environment in which authority, behavior, and perception were inextricably linked. The Caldwell episode had become more than a single viral headline. It had evolved into a tangible lesson in the interplay between law, strategy, and accountability, proving that even the most high-profile figures are bound by the rules of the judicial system.